Judge overseeing the long-running racketeering trial against rapper Young Thug has been removed from the case. After two defendants sought Judge Ural Glanville's refusal of a meeting with the judge and prosecutors, as well as a
he had to go, bro.
ABC legal contributor Brian Buckmeyer is here to break it down for us. Brian, this is a major ruling. How did this happen, and what happens next?
So as you said,
how it happened is easy. He chose to be
prosecutors
completely biased, and he chose to do that. This was all his choosing. He chose to be biased and prejudiced. No one forced him to do it. He did it on his own. So this is, of course, news update on Judge Glanville being recused. Something I said needed to happen. And the judge that recused him is his colleague. I mean, she works with him. So, but her, I think Judge, was it Krause? I mean, it's his colleague. But either way, he needed to be recused because this case has to move forward. And the only way to move it forward is to get a biased, prejudiced judge off the case that should have been recused himself without having to be ordered to do it. Because no one should be telling him to recuse himself. There was reasonable question of some biasness and a failure to remain impartial already proven here. And I'm talking about proven and stated from 2 or 3 different attorneys. And plus, you're not going to take away what we, the public, have witnessed with our own eyes and ears. I mean, we know what we've been watching and hearing. This case has gone, another one that has gone global for all the wrong reasons. You're not going to tell us we didn't hear and witness and see all the things that we saw as the public when it came to this case with Judge Glanville. I mean, he went viral because he started acting unethical. And once I know me personally, I didn't even keep up with this case until, it was reported that he unlawfully, had an attorney, an officer of the court held in contempt and incarcerated. You brought this on yourself. You had to be removed after that. You don't just lock people up because they won't answer a question and give you a name. Where we do that at? This is the United States of America. We're not playing with you. That's ridiculous. So he had to go. He had to go.
That's ex parte, not typically allowed to happen. And so when Judge came out, and Brian Steele, the attorney for said, hey, I found out there was a meeting and I wasn't a part of this, and you didn't even tell us what occurred there.
Exactly.
Kenneth Copeland is not pleading the fifth and testifying. We need to find out about that. And that's when these motions started to fly. What ultimately happened is the Judge Glanville gave this case to Judge Rachel Krause, and she just handed in a decision yesterday and ultimately decided that the way that the judge handled the case, even the ex parte, was fine, but the way he came out...
But that's not something she can determine. She wasn't there. She can't say that.
Communication was wrong, and that was the basis.
First of all, her opinion is that it was fine. In her opinion. That's not something that she can even prove factually in her order because she was not there. She didn't witness it. And if you just go based on the ex parte transcript of what had been, had been stated and transpired, I mean, you can't say that that's 100% if there is any allegations or any proof to show that it may have been some redactions done to the transcript. So when you have them saying, okay, the transcript may have been redacted and tampered with, it's only so much you can say about this being like that ex parte meeting being fair or there was nothing wrong with it, fundamentally, or the technicality of how it was conducted. How can you say that? You may not have a reliable transcript to even utilize to say, yes, I can confirm every single word that is listed on this paper was said and that there are no words missing. Okay, that's some benefit being invoked into the matter. The state has to prove beyond a reasonable doubt. That's the burden that they have to meet in this matter. In this criminal proceeding, you got to prove beyond a reasonable doubt. But when you have reasonable doubt into question, you have the average person that would say, you know what? I can't trust this transcript. How do I know that you all didn't redact anything? Or that you didn't tell the court reporter, unless you only type words I say, you going to jail too. Because Judge Glanville has a bad habit of wanting to incarcerate people. This is why you don't sit on a case once you're somehow you failing to remain impartial has been reasonably questioned by the Georgia Supreme Court based on their ruling. The parameters to which they outline in a ruling says you should have recused yourself because you're a grown man and no one should have had to tell you to do that. And you don't have a judge that can say for sure as a matter of a fact that there was nothing wrong with the ex parte meeting when she was not there, allegedly. She was not there. She can't make that call. She can't say that was done appropriately according to court rules. How? And you don't say that. So if it's not a fact that you're giving, even the judge writing the order should either state whether that's their opinion or be able to produce some evidence to support what sounds like a factual statement being made that she can't make because she wasn't there, and she can't say 100% that the transcript from the ex parte meeting was not tampered with. So what are you basing that off of? It's your opinion then, and it should be stated as the opinion of the court, not as a fundamental fact that you can't prove with any evidence. That's where we are now, because no one owes Judge Glanville any level of trust at this point, which is dope.
In this case, as it goes forward.
Now, you spoke to Doug Weinstein.
He's too happy to throw people in incarceration. What is that?
What are they preparing for now?
Yeah, so Doug Weinstein represents DeMonte Kendrick, or Yak Gotti as he's known, and he was just as shocked when I spoke to him yesterday. I actually spoke to him while I was in his car, and what he's preparing for now is what comes next. His understanding is that
they're going to ask for a mistrial. That's for damn sure.
Where the issue occurred, the issue being when Kenneth Copeland took the stand. But if you go that far back, the jury has already heard some of what we'd call tainted evidence from that testimony that arguably should have never happened.
But should have never happened though, because he said he wasn't going to testify. So it should have never happened. That's something the court gonna have to eat up. We're gonna have to roll this back and take the hit for it.
Right? This trial has been going on such a long time already. What happens if they have to start?
Good Lord.
You start from square one.
You start from square one, but you really should. They gonna be asking for a mistrial. I mean, seriously. They got case law. Are we gonna ignore all that precedent's already been set? We're ignoring precedent set judges at Fulton County Superior Court. Is that what we're doing? They're ignoring Georgia Supreme Court rulings. My Lord. Woo, child. Nothing. Okay, so
overseeing the long-running racketeering trial against rapper Young.
I mean, I said this in a video about 14 days ago. I said flat out he needed to be recused, because you get these attorneys that's been going to law school, honey, and Brian still is known to be one of the best defense attorneys in the state, you know, and look what he had to endure. What is it to a random regular person like me who pays taxes and vote for these judges? God almighty, we vote for you. We vote for some of these judges. My Lord. But what is it a regular person like me, what chance do I have going to Fulton County Superior Court when top defense attorneys in the state of Georgia are being incarcerated and held in contempt by a judge because he wants a name and you're not giving it to him? So now he's going to throw a man baby tantrum and he's going to lock everybody up. You're showing us your hand. You can't undo that. We can't unsee what he's done. And that's not something you just unravel with him being removed from one case. No. You want faith restored to the public? No, you get that unraveled. Get him removed from the bench. That's how you unravel all of that doubt. Because this is what he has done in a case that has gone on for 2 years too long. I mean, it's just been going on for a long time. That I will agree to wholeheartedly. But the judge being biased and prejudiced. And then on top of everything else, he's so quick to throw people in jail. We need a show cause hearing on why y'all not giving me a name. I don't know why is that an issue? What was so horrific about that? For you to feel like it was okay to do a show cause hearing, or else people would have went to jail from that if they didn't show up. Or you're willing to sit here and incarcerate an attorney. The defense attorney. You're not doing this to the state. You ain't doing it to none of those prosecutors and ADAs and DAs. Let's see you sell the DA. She got to go to jail for 3 days. Let's see how that go. I don't understand this. You're not doing this fair across the board to all the attorneys. You're just doing it to the defense attorneys. This is ridiculous, bro. You can't do that. You can't do that. You're literally showing us that you being a gangster boo from the bench. You can't do that. The average person come in there, they're going to be like, I don't want this judge on my case, because if he throws an attorney in jail for not giving him a name, what chance do I have? Like, that's not just, I want to restore faith, and, the public needs to have faith restored. You restore our faith by removing him from the bench. That way you can spare other people. They don't be thrown in jail unlawfully because reasons. He did this to a man that went to law school and got a Juris Doctor degree like he does. You can't say he's not going to try that on some unsuspected, just tax-paying voter that wants to represent themselves as their own defense. Good Lord. You got a lot of defense attorneys going to be walking around saying, I don't want Judge Glanville on my case. I filed a motion for recusal off back. I'm not doing this with him. No. He showed the world who he really was. And I highly doubt this man acts like this just on the bench. You got people saying, he was fair once upon a time. I don't know how, when he is so willing and quick to say, I'm locking you up. You don't tell me a name. I'm locking y'all up. Y'all don't come to a show cause here. I'm locking you up. If you come and you don't say what I want you to say, I'm locking everybody up. That madness, nobody wants that overseeing their case. Nobody will want him overseeing that case now. You're going to have defense attorneys. 25 of them showed up with Ashley Merchant just to try to get their fellow attorney out of being held in contempt and incarcerated. This is what you're having to deal with now. How do you expect those 25 attorneys to not see Judge Glanville as a very biased and prejudiced judge now? When they all went down there, and Brian still has the right to have representation with him for his case, for any case involving him as a defendant, you holding him in contempt of court. He had the right to ask for a hearing on that. Just like you have the right to get a hearing on why you should be recused. Because we have precedents. What are we doing? Just because the judge doesn't like the court ruling from the Georgia Supreme Court doesn't mean that we're not upholding this precedence. It doesn't go away because he doesn't like it. That's his job to uphold it. As well as the Constitution and state statutes. You have case law that exists for a reason. I don't understand why he pretends like case law does not exist that have warranted him to have to recuse himself and not have someone else do it for him. That's the issue. He should not have had another judge have to even make that decision. He should have made it once the impartiality of his court and his overseeing of this proceeding was reasonably questioned. Period. No one is asking you if you like the fact that an ex parte hearing occurred. It's the fact that it should not have occurred. And it violated a lot of court rules and case law and state statutes when you didn't have the defense attorney present. And then his issue was give me a name, not the fact that, it was authentic because blah, blah, blah. Nope. He didn't even try to defend the ex parte meeting. He tried to dodge and deter from the topic of that by making an issue about him not answering a question now. Oh, I told him to do something. We don't care about that. We don't care about that because we know why you did it. And the average person can see that. You don't need to go to law school to see the purpose of what he was trying to hold Brian Steele in contempt for over. It was all about a distraction to keep him from even focusing on or even making a record about his motion in good faith on an ex parte meeting that should have never occurred. He wanted to sit here and make an issue about he didn't do what I told him to do by giving me a name. Who cares? Who cares? What you're asking for was improper. So if the judge is going to say things like that in the order, then make it known that it's your opinion, because it's certainly not a fact. It's not a fact at all. I don't know how one judge against other judges and attorneys that have given commentary on this situation. I mean, whole attorneys going in these videos. And I'm telling y'all right now, some of these attorneys, they're not happy with that. And they shouldn't be. Who would be happy hearing someone say, oh, I'm gonna throw you in jail if you don't give me a name? And you're also a defense attorney as well. And you're seeing this happening in real time over an improper meeting that should have never happened at all in real time. And even if the state wanted to force their way to some sort of ex parte, the judge could have shot it down and said, nope, y'all meet with me when the defense attorney gets here. I'm going to leave this to you all. If it's that important for y'all to have this conversation with me and a witness that just was sworn and gave testimony that didn't want to testify, we're going to wait for the defense attorney to get down here. He could have chose to do the right thing. He chose not to do the right thing. And then he forced Judge Krause to have to do it for him, which is highly unacceptable when you're talking about what does the Georgia Supreme Court ruling say. When your impartiality is reasonably questioned, reasonably put into doubt, reasonably challenged here, you recuse yourself just to kind of keep that confidence with the public that you're going to do the right thing. Not you sitting here trying to make excuses and dodging it because you're making this about your ego and pride and not about doing what's right. At the end of the day, that's what it comes down to. What is right and just? What is the state statute? What is case law and precedence that's been set? What does that say? He should have just did it. They could have had a new judge on this a long time ago, probably 2-3 months into another trial. But he didn't do it. He was being defiant. And this is not about restoring the public trust. This is about making sure this case moves on. Because that's all the new judge is talking about. But where's the consequence to Judge Glanville for even doing half of what he did? What real consequence does he suffer in this? Yeah, okay. The answer is none. He's still on the bench. He's not being disbarred. He should have been reported to JQC by now. And there should definitely be an investigation regarding his bar license and competency. I mean, the Georgia Supreme Court knows how to get rid of incompetent judges. They've proven they can do it. They did it with Christina Peterson. They've proven that. That can be done here. At least an investigation be done. Because there is no way we as the public should have witnessed on live television a judge show how partial they are, not impartial, how partial they are, how biased and prejudiced they're being against the defense attorney, especially a specific defense attorney in a case where you got at least 6 defense attorneys. You're showing your failure to remain impartial on national television. This man did this on television, on TV cameras. What does he do behind the bench? That's what the public doesn't have any faith in. We don't trust what he does when the cameras are not rolling in his courtroom. We don't trust that he's not going to sit here and just keep locking people up unlawfully. And the only way you restore that trust is there's an investigation with JQC launched, or the Georgia State Bar at least tells the public that they're investigating him because of his actions or lack thereof. But that's not here. No. No faith has been restored because This is the chief judge doing this on national television. And he did it for weeks on end. And then he refused to stop doing it when he knew that he was messing up. He didn't try to correct his actions at that point. No, he didn't. He knew that what he was doing was improper and inappropriate. And he did not try to stop his own actions, or to at least try to put an end to it, and recuse himself a long time ago. Nope. His colleague had to do it. And then she puts opinions in there like this somehow a matter of a fact that should be clearly expressed as an opinion, because you can't give credibility to an ex parte meeting if you weren't there. You can't say whether it was just or proper. You can't say that assuredly. So it was just your opinion of that. And albeit he needed to be recused, it came down to who was going to be the one to recuse him. Because had Judge Krause denied it, that would have been appealed, and then it would have went to the Georgia Supreme Court, and then they would have sent back an order, probably with a scathing review on why these judges are not trying to hold each other accountable. We have the Georgia Supreme Court. It's like the granddaddy. They like Peepaw with the belt, them thick leather belts. When they need to give a spanking, you know it's gonna hurt for a couple days. Yeah, they're Peepaw. Georgia Supreme Court would have been like, what the fuck the County Superior Court doing down there? What y'all doing? This case had to come back to us. We were really hoping you all would be a check and balance unto yourselves. Did we not tell you all in a ruling how these go when it comes to recusals? Do you not have case law and precedents on this already? You're citing our ruling up here at the Georgia Supreme Court, and y'all still want to act like it doesn't exist? Oh, okay. Like we didn't tell y'all to do this already. They would have sent down a scathing review, and they would have been highly perturbed at the thought of having to even hear that matter again. This time after it climbed this way through the chain of command and still ended up in an appeal process, now with Georgia Supreme Court. They would have been so pissed off, it would not have been funny. And they would have gotten on these two judges for declining and denying a recusal when it should have been done. It should have been done. And the Georgia Supreme Court ruling is clear on that. So they would not have been too happy about having to issue down a ruling with a scathing review and you know, because the U.S. Supreme Court does it all the time. When they don't like something, boy, they operate an opinion in a minute. We did not vote for this, and here's our condemnation against this collectively. They're good for that. But that's the same thing the Georgia Supreme Court would have done. They would have said, you know what? We should not have had to even issue this ruling, because somebody at Fulton County Superior Court level should have told their colleague that he should have recused himself, and what he's doing is improper. Even if he wants to say the ex parte meeting was what it was, once it was properly challenged about his recusal, he should have recused himself. And now he's just being defiant, and we ain't got time for it. Not up here. Not on the Georgia Supreme Court level. They would have told you all flat out, y'all better get your act together down there. Don't make us come down and pull out the belt. That belt being, I'm telling y'all, they would have sent a scathing op-ed. An opinion of Georgia Supreme Court. We have a ruling on this already. We're not going to repeat ourselves no more. In the end. You kidding me? Y'all literally making us make this decision? Nobody down there could do that? No one sees that this recusal needs to happen. Really? Come on. She knows. Judge Krause knows. If this goes to the Georgia Supreme Court, they're not going to be too happy with none of us down here. They're going to really go off. So somebody need to make the call. But luckily she did. It doesn't restore my faith in the judges. It does not. Because he is one of many that behaves that way. And having him recused was what he should have done on his own. It does not restore my faith in any of those judges at Fulton County Superior Court. Not even a little bit. Not even a little bit. Because you have the chief acting like this on national television. I'm sure that he has somehow swayed others to behave in the same manner that hasn't been on the bench long themselves. And some of them are elected. Some of them are elected. You about to get a lot of judges up there, Judge Glanville, messed up by passing on this bad behavior. You about to get a lot of them messed up. They're not gonna be voted back in. We're not gonna keep re-electing people that is being biased against the people that voted them into these judgeships. We're not doing that. So what you passed on was a horrible precedence and cycle of behavior that unfortunately cannot be unseen. You can't undo this. You can't. It's already out there. You've shown your tail for the world. You got the world watching, and this is what you choose to show them. There's no restoring faith in that just by one recusal. Because now, if I were a defense attorney, I would say flat out, I don't want none of my cases with him. Now you're going to have an influx of people just constantly asking you to be recused. Because they're not going to tolerate that nonsense. They're not going to put up with that again. We've already seen it for ourselves. When no defense attorney is going to want to put their liberty and freedom on the line in front of you when they see how quick you are to want to incarcerate someone, a fellow officer of the court. This is crazy. I don't want to hear no attorney's mouth about nothing I say when you got a judge that is not that giving two craps either. That judge said, I don't care, y'all went to law school like I did and passed the bar. Don't mean that to me. I'll lock your asses up. God almighty. This is nuts. You're just locking them up. Thank you, Judge Gangster Boo, for showing us who you really are. We appreciate it. We have no faith in him or any of the judges underneath him. None of them. None. No, ma'am. Sorry, Judge Krause. No faith has been restored at all. Not even a little bit. None. We have none. 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 All right. So that's my 2 cents on this. I have a case coming up. It's just, child, boo. Oh, Lord. That should have been heard by the presiding judge in my case on the final hearing on May 28th. And that wasn't done. And there's a whole court rule invoked. I'm curious as to how that's going to be handled. They already keep saying that I testified to things when I don't even speak. If I have an attorney, I'm not speaking for myself. I'm not pro se. And then, if I do speak, they don't care. But you're not also I'm not being placed on an oath and affirmation. So how am I giving testimony? Like I already said flat out, I'm not going to keep going back and forth with a court. You're proving that you're being biased by accusing me of testifying when I don't even testify. I'm not giving an oath, affirmation, or the opportunity to even speak. When did this testimony come about? This is what they are putting in writing, in emails. So, I don't know. Bad luck already rubbed off from Judge Glanville. You got other courts down there accusing people of saying things or testifying when they don't. How much more worse is this going to get with Fulton County Superior Court is my question. Nobody should be putting that in an email. Ever. You testified to this. I could debunk you all day. Do you have the time? It's a question. No, ma'am. Nobody testified to that. That's a judge forcing his will upon me and my wallet that I can't even afford. Now another judge did it again today. A second judge did it again today. Okay. All right. So this is apparent. Like I don't know what the game plan is, forcing someone to have an attorney they cannot afford, and you're therefore pushing them into a harder financial burden. I don't know what the purpose of. Okay. Yeah, I could go down my whole issue right now, and I promise you, it won't change a thing. They'll probably watch these videos, and it still won't change a thing. You gotta want to do the right thing. You have to want to do the right thing, because right now I have a motion. I need to file, but I can't because I'm not pro se, and I can't force my attorney to do it either for free when I can't afford them. When the judge should have honored the court rule, remained on the case, and heard the final hearing on May 28th. And I have another judge come in and effectively stall this stupid case even the more by 3 additional months when my children are old enough to speak for themselves. So when you did that, you allowed this judge to come in against a court rule and push this back by additional 3 months. But me filing an appeal, though, would have definitely delayed it. Explain this to me, how this works again. So when I said I would appeal a judge's order that is unlawfully, unjustly decided upon, and out of retaliation, I don't even know what objective reason they have with that. What is the legal objective excuse and explanation for this? No? None? Got it. Okay. So you're doing this all on your feeling. No one's using evidence. Not even a little bit. Not once was evidence applied in any ruling at all. Just a bunch of judges' opinions. No case law cited, no state statute, no nothing. Didn't show what law was broken, nothing. Nothing. So this has all been subjectively decided based on somebody's opinion, which is what the Constitution warns against. And because of that, now we still have this matter going on. I've been the one saying that this case got to come to an end. But that's how these judges down here operating. Now they got their staff lying in emails. You put it in writing that I testified. I'm sorry. I need you to produce a transcript. I want the court of record. I want either the video hearing or transcript to prove that I said anything. Because nobody could tell me how much money I do and don't have. I mean, that's not something anyone else could tell you but me. And last time I checked, there's no such thing as debtor's prison. You don't go to jail before being broke as hell, do you? Is that a thing? We're still doing that in the U.S.? Okay. This is all the nonsense I've been dealing with judges down at Fulton County Superior Court. Because of reasons. But they lock you up, though. If you sit here and exercise your First Amendment rights, they're going to lock you up. The attorney is going to ask the court to sanction and throw you in jail for First Amendment rights. Funny how that stalking my YouTube channel is not a violation of law. And that no name said, just the situation is ridiculous. It's unbelievable. That's why I say I can't have my faith restored in none of these judges at Fulton County Superior Court, because I'm still experiencing biased judges at Fulton County Superior Court. It's still happening. Even if you know that they can be voted out, they still do what they want. Reasons. I don't know. They still put weird, dumb things in emails that don't belong there. It's a flat out lie. Woo, child. All right. Okay, that's all I got. Judge Glanville has been removed. He had to be recused. It was absolutely necessary. You don't have judges just threatening with incarceration to other defense attorneys or attorneys in general. I mean, he was blessed to get that judgeship. But certainly there were others just as qualified, I'm sure. So the last thing you should want to do is abuse your power and authority. That's the last thing you should want to do. You got to correct that. Make it right. Otherwise, there's no way you can get the public's faith restored. Him being recused was based on case law and precedents necessary. But the fact that he was so defiant and really showed his true colors on national TV, and he's a chief judge. He's been out there just as long as a lot of those judges have. And you have a couple of them that have been down there not even that long. They become a chief judge or a presiding judge or however, and then they ended up being just as bad, if not worse. You can't say that's not rubbing off Judge Krause. What Judge Glanville has done, he's been doing for almost 20 years, apparently. Because he was very comfortable with doing it on national TV. You can't cut that off after almost 20 years of that. You imagine what has gone on behind closed doors without a camera in there? Can you imagine? Yeah, we can. We've seen it for ourselves. We witnessed it all. It was live streamed. It was on national television. It's gone global. People are saying hello from Germany. This is how you all act in the U.S. I'm sorry. I don't know what to say. They shouldn't be. But what can you say? this is what we've been witnessing down here in the state of Georgia and in Fulton County, you know. And at the end of the day, like I said, these judges, even though knowing that they're elected, some of them are, you know, you got those that just don't care. They don't care about the people that voted for them to be in those positions. They're biased against their own people. Don't think black people can't be biased and prejudiced against other black folks. That happens all the time. Child boo. That's, you know, so the skin color, all that, none of that stuff, the Constitution doesn't care about it. We shouldn't either. We certainly should not allow, whether we like someone or not in a courtroom, to take control of our thoughts and emotions and ability to make decisions. But that's judges, they say they people too. I mean, they are. But don't pick up bad behavior and bad habits. And don't let it get to your head. You're serving the people that voted for you to be in that role. You know, wear that with some dignity and pride and humility. Not being prideful and controlling, but being, you know, wear with pride as in I'm proud to serve the people that voted for me. And that gave me this level of trust to be able to make decisions that are objective, you know, and that are done with facts and evidence. Not their opinions and thoughts and emotions. That's not what you want. So, either way, that's Lady Luck Club, and I'm out.